This looks like a longer op-ed piece on the suspension of habeas corpus. So, if you've been following along with all of the due process nonsense, there's been serious questions about the Trump administration's respect for the rule of due process in our legal system. They shipped away a number of people to El Salvador without any proper due process or court hearing or ruling that they're supposed to do so, stripping them from their ability to prove their innocence. Um, they argued very cynically and incorrectly that we don't have the capacity to give everybody, all of those people, a proper court date. That is just not true. That's how we've done things since the beginning of this country. So the assertion that we don't have the resources to do that is absolutely ridiculous. Um, and the idea that we would suspend habeas corpus for anybody is antithetical to the concept of the United States. Um, you're supposed to be, just by virtue of being a human being, existing in the United States, whether you're here legally, illegally, whether you're a murderer or an innocent child, you are deserving of your day in court. You're innocent until proven guilty, and that is a core tenet of the American dream. That you aren't going to be oppressed by some tyrannical government who decides unilaterally that you've committed a crime based on evidence without it actually being proven or possibly no evidence at all. And so this is especially scary. There's been a number of people in the Trump administration lately that have been floating the idea of suspending habeas corpus, which is my understanding is the concept of due process. They're wanting to they're wanting to suspend habeas corpus for certain groups of people. They want to essentially create a second class group of not citizens but of human beings, um, those who are undeserving, have not met the qualifications necessary to receive a proper court hearing or whatever. But anyways, this is a longer op-ed piece. Let's see what it has to say, and let's get right into it. The astonishing threat to suspend habeas corpus. The White House driveway is an unlikely venue for announcing plans to upend the Constitution. But strolling back to the bank of microphones on a sunny spring afternoon, the White House Deputy Chief of Staff Stephen Miller seemed delighted to share the news that the Trump administration is actively looking at suspending the writ of habeas corpus, the fundamental constitutional right of those who have been detained to argue in court for their release. So that aligns with my understanding of what habeas corpus is. Basically, it is the broad concept of due process, your right to a day in court, innocence until proven guilty, yada yada yada. This was this was, to all appearances, no casual aside. Rather, the question that prompted Miller's remark had all the earmarks of being planted in advance. Before taking any other queries, Miller pointed to the back of the crowd, where a reporter from Gateway Pundit, far-right website, asserted that Trump had been discussing taking this controversial step to take care of the illegal immigration problem, and asked when could we see that happen, do you think? Miller's reply was delivered with his trademark style, condescension undimmed by any recognition of his own ignorance. The New Yorker hires some good writers. This is really well written. That's such a great little backhanded like diss. It's so good. This I need to read that again. Miller's reply was delivered with his trademark style, condescension undimmed by any recognition of his own ignorance. That is so good. I love it. The Constitution is clear, and that of course is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. He put particular stress on the second syllable of supreme, as if some pesky court might be trying to flex its muscle at constitutional expense. Yeah, I like how this article, right from the start, is pointing out that the language and that the way that they are attacking this is very calculated and very specific and very purposefully manipulative, and that it takes a skilled reader, somebody who has decent reading comprehension skills, to be able to actually parse out that from, actually for good faith speech. Also, I'm sure, or I have a feeling this article is going to get into this into more detail, but the idea that uh, there's an invasion going on is entirely illegal. And what I mean by that is the word invasion has a meaning. Words have meanings, right? Like words are can change meaning, but words have established meanings. And an invasion requires somebody to be sending people. You cannot argue that a whole group of people on their own volition deciding to illegally cross the border or illegally claim asylum or correctly legally claim asylum, that they're being they the idea that that is an invasion is not it's just not correct. It's not that doesn't align up with the definition of invasion. Invasion requires somebody to be sending them. Okay. An invasion is like when a government sends a military to do something. Um, it doesn't even have to be a government when it is a directed, coordinated effort. There's no evidence that, like, to the extent that immigrants have made their way into the U.S. or gangs from other countries have managed to establish here, um, nobody is sending them. It just happens. They're all doing it on their own volition, um, and so that's why this doesn't make any sense. Is it's the word invasion means something, and they're trying to obfuscate the meaning of the word invasion and use it cynically to their own extent. The lecture proceeded with Miller asserting that the Immigration and Nationality Act had decreed that Article 3 courts, federal judges with lifetime tenure, in contrast to immigration judges who are part of the executive branch and can be fired, aren't even allowed to be involved in immigration cases. Many of you probably don't know this. That seems insane to me because the no, that is not okay. So if immigration judges can be fired by the executive. That means that they aren't really judges in the same capacity that like a legal judge would be. They probably are like they just have the word judge there, but the word judge is being used very differently in that sense. And this is the separation of powers. This is like by definition an issue of a separation of powers, right? Um, the whole point of separation of powers is so that not one branch can get too powerful and do things that are oppressive or steps on the toes of the jurisdiction of the other branches. Or the idea of checks and balances is that each of these branches of government keep themselves in check. And so it's important that judges that are completely separate from the executive branch are able to review decisions and actions made by the executive. If immigration judges who aren't really judges, who are oversought by the executive, are the ones themselves that are in charge of overseeing if the executive is doing things correctly. You see where the problem is there, right? They can't oversee themselves. That doesn't make sense. And so this whole thing is ridiculous. And the assertion that immigration judges are the only ones that should be able to make rulings with regards to immigration policy is r- just ridiculous. It's so ridiculous that even this ridiculous Supreme Court, I would imagine, is not going to support that argument. Where to start with the things that Miller, who is not a lawyer but happy to play one on the White House driveway, probably doesn't know. As the Georgetown University law professor Steve Vladek aptly summarized, his argument is factually and legally nuts. Yes, yeah. Miller misunderstands the significance of the right of habeas corpus for starters, known as the Great Writ. That is the foundation of our entire legal system. It is the foundation, I would argue, of like modern human rights almost, right? Like the idea that you would attack habeas corpus is so beyond the pale. I would have never guessed. I would not have guessed a year ago that this would be on the table. I would have never guessed. Known as the Great Writ, It is an ancient right dating at least to the Magna Carta's declaration that no man shall be arrested or imprisoned except by the lawful judgment of his peers and by the law of the land. The Supreme Court has described it as the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. For the drafters of the Constitution, habeas was such a critical aspect of personal liberty that they put it in the original document, not waiting for the Bill of Rights, a point the court made in a 2008 decision establishing that the right extended to non-citizens held at Guantanamo. Miller's spin notwithstanding, the Constitution makes clear that the right to habeas corpus is the norm, not the exception. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. Rebellion and invasion have very specific definitions. You can't just change the definition of the word invasion. That's not how this works. That provision is in Article 1, which outlines the powers of the legislature and illuminates the second thing that Miller got wrong. Only Congress has the power to suspend habeas corpus. The president can't act unilaterally. Yes, Lincoln did so in 1861 at the start of the Civil War. He was slapped down by Justice Roger B. Taney. Yes, that Taney, the author of the Dred Scott decision. Taney wrote, I can see no ground whatever whatever. I can see no ground whatever for supporting that the president in any emergency or in any state of things can authorize the suspension of the privilege of the writ of habeas corpus. That seems like it makes sense to me. Why would the president have the power to unilaterally decide to suspend habeas corpus? That seems sort of antithetical to the whole like idea of the formation of this country, which was we don't want to have a king, right? We don't want to have a monarchy who just rules by virtue of bloodline. Um, wasn't that the whole point of the founding of this country, right? So it makes sense that makes sense to me. Um, it makes sense that you should and that you wouldn't need Congress to back this. Taney, in a practice that continued until the early 20th century, was sitting as a circuit justice at the time, and therefore his opinion is not a ruling of the court. Notably, Lincoln didn't appeal it to the full court, but he later defended his reasoning, explaining it in a message to Congress that, as the provision was plainly made for a dangerous emergency, it cannot be believed the framers of the instrument intended that in every case the danger should run its course until Congress could be called together, the very assembling of which might be prevented, as was intended in this case by the rebellion. Okay, so that makes sense as well. There are scenarios you can imagine where you would need to suspend habeas corpus or do some sort of big action like that, but Congress is unable to meet and properly authorize it. But then you could just have a provision that says, like, if Congress is unable to meet, then the power rests in the hands of the president. That would make sense to me. And then also have some sort of provision in there, obviously, that the president can't himself facilitate Congress not being able to meet. But I think that goes without saying. Although with this administration, nothing goes without saying. Even things that go with saying they're gonna just ignore sometimes. So I don't know. If you think presidential power to act remains a disputed question, consider this 2014 assessment from Amy Coney Barrett, who was a law professor at the time. Scholars and courts have overwhelmingly endorsed the position that Lincoln's unilateral suspension of the writ notwithstanding, the Constitution gives Congress the exclusive authority to decide when the predicates specified by the suspension clause are satisfied. Okay, so that's her saying that Congress is the only one that can make this decision, and that the president does not have the ability or the right to suspend habeas corpus unilaterally using just the executive. And the fact that Tony Barrett said that a few years ago means that I would expect her to hold that same position, on top of the fact that she is one of the few that's willing to go against the administration, a bit more willing than like Alito and Roberts. That brings us to Miller's third error, that even assuming Trump could act on his own, the grounds for suspending habeas corpus exist. This is not Lincoln confronting the rebellion of the Southern states. And consider the other instances in which presidents, acting on emergency powers delegated by Congress, have suspended habeas corpus. After the bombing of Pearl Harbor, during Reconstruction era rebellions in South Carolina counties overtaken by the Ku Klux Klan, in the Civil War, and in the Philippines. In 1905, in the midst of the Moro Rebellion against American rule, ignore Miller's hyperventilating. The country is not now facing an invasion, much less one in which public safety requires suspension of the writ. Trump has invoked the 1978 Alien Enemies Act to round up and remove alleged members of the Venezuelan gang Tren de Aragua. At least four federal judges, including one nominated by Trump and another by George W. Bush, have rejected that interpretation. Yeah, you can't just invade. Like I said a couple times now, the word invasion has a specific definition. Words have meanings. And the idea, but furthermore, put that aside for a second. The idea that like the the uh, the flow of immigrants into this country is an invasion, a la, Civil War Reconstruction Rebellion or the bombing of Pearl Harbor, is just like any sane, reasonable person can realize that's just ridiculous and wrong. Then there is Miller's baseless declaration that Article 3 judges aren't even allowed to be involved in immigration cases. That's evidently false in the cases involving the Alien Enemies Act. Last month, the Supreme Court instructed that challenges to Trump's actions had to be brought as habeas cases. More broadly, though, the Immigration and Nationality Act sends some cases to specialized immigration courts. It does not, as Miller claims, require Article 3 judges to butt out entirely. For example, in the case of Rumeysa Öztürk, the Turkish graduate student detained for writing an op-ed critical of Israel in the Tufts University student newspaper, the administration contended that the INA prohibited the federal court from considering her habeas petition. In a ruling last week, the U.S. Court of Appeals for the Second Circuit rejected that argument, saying that the government dramatically overstates the reach of the immigration law. A federal judge ordered Ozturk released after more than 6 weeks in detention. The law is nowhere near as definitive as Miller claims, and the notion of suspending habeas corpus is so outlandish that it's tempting to ignore his assertions, dismissing them as more Miller trolling. No doubt there is an element of rabble-rousing at work in his hyperbolic warnings that courts ruling against the administration in immigration cases are engaged in a judicial coup by a handful of Marxist judges, which can only be understood as an attack on democracy. That is, bro, come on now. Marxist judges, bro. Can you find a single judge in the United States sitting right now on a bench that self publicly and openly self-describes themselves as a Marxist? There is no way, okay? If you can find that for me, I'll Venmo you $20, okay? Because I almost guarantee you it doesn't exist. It's just it's so ridiculous. It's the same. It's almost like it reeks of the same people that screech cultural Marxism when it doesn't mean anything. That doesn't It's just non-existent and it's just so silly. But there is something more meaningful going on here. The not so subtle implication is that judges ought to think twice about standing in the administration's way, lest they trigger a suspension of habeas corpus. Asked whether Trump would take that dramatic step, Miller offered, "Look, a lot of it depends on whether the courts do the right thing or not." In the administration's view, the only good court is a compliant court. That is very true. They seem to not respect legal analysis whatsoever. They seem to only care about meeting their ends. And if the court rules against them in some kind of way, they're regardless of the ruling, regardless of the court, they are going to and like an apolitical, uninformed person might argue, well, that's just the legal world, right? If you're that seems like just smart gamesmanship, right? Basically. But if you have any historical understanding of how presidents and the legal system has functioned up until now, you'll understand that The way that the Trump administration is actively attacking the courts is totally, it is not comparable to anything we've seen in the past. Um, their willingness to um, act in such dramatic bad faith to achieve their what I would call bad goals is uncomparable to anything we've seen before. In the administration's view, the only good court is a compliant court. That is not the way the Constitution works. Marbury v. Madison from 1803 dictates that courts emphatically have the last word on what the law requires. But for this administration, due process is worse than an inconvenience. It is an obstacle to be avoided at any cost because any review of the legality of Trump's actions might prevent him from carrying out expulsions at the dizzying pace he seeks. That is why the White House resorted to the unprecedented use of the Alien Enemies Act outside of wartime, and why it has been so desperate to prevent judges from getting to the merits of other cases, such as that of Kilmar Abrego Garcia, whom the administration sent in violation of a court order to a maximum security prison in his birth country of El Salvador. J. Harvey Wilkinson III, federal appeals court judge, made this point when he wrote of Abrego Garcia. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. As Wilkinson noted, a government confident of its position that Abrego Garcia is a terrorist and a member of the MS-13 gang would have nothing to fear from due process. Exactly, yeah. If they have sufficient evidence, then you would think that they would think that they would not only be willing, but they would want to prove it in court because there would be no question then. They don't, I would imagine that they do have planned controversies and sort of their political version of planned obsolescence. Like they absolutely stir the pot on purpose, but I would imagine that would like to have avoided all of this due process, habeas corpus nonsense because it's just a bad look. I would think like if they could create an alternate universe where they didn't have to do all of this, they would, and that ultimately this is a bad look, and that yeah, most of the cult members are not gonna give a shit, but that anybody who was sort of in betweeny and found themselves voting for Trump because maybe they're just more like a fiscally leaning conservative, but they don't agree with everything that he does. There's no way that this due process stuff looks good to them, and they know that. Habeas corpus and due process are intertwined. The right of the detained individual to seek review in court is a way of making certain that due process has been provided. Seemingly frantic to avoid having its actions subjected to scrutiny, the Trump White House is now weighing whether to trigger a constitutional earthquake. Even short of that, Miller's pushback pitch to the federal judiciary on habeas of a piece with the administration's consistently thuggish language about rogue courts is disturbing enough. The administration's bellicose stance against backfire with some judges, but it could also have the intended chilling effect. Chief Justice John Roberts is temporarily inclined to avoid a Lincoln-Taney showdown. Either way, this is a perilous moment. For all the extreme legal steps the administration has already deployed, suspending habeas corpus would be an act far more radical than any that has come before. That we are compelled to take Miller's suggestion seriously is a measure of the gravity of the threat to American democracy. Man, whoever wrote this article, they do words good. What's the name of this person? Ruth Marcus. Ruth, you do words good. I don't know. Ruth could be a girl or a guy. But Ruth, you do words good, all right? All right, Jones? All right, Jones, you do words good. Yeah, I like this article. Gives just the right amount of historical context without getting too buried into like a history lesson. Um, Points out the cynical framing and bad faith nature of Miller and of the administration's approach to the legislative branch of the government in general, um, and points out the completely legal reasoning that is presented on this, the completely devoid from any like precedent or any legal logic or reasoning that makes sense. This article is well put together. I think I have one more article talking about the suspension of habeas corpus. Do I? No, I don't. Okay. Well, I think that was about it. Don't know if there's a whole lot more to say about that. It's just really scary that, they're even discussing it, that you have the attack, the trolling Rottweiler that is Miller coming out and making statements like this. I think it is good. I think the speculation that they're doing it cynically and on purpose and that this is more arc than bite, is probably true, but I think it is absolutely still worth talking about and still we should still take it with the utmost seriousness, especially considering the crazy nonsense that this administration has been engaged in for the last 4 months or whatever. With especially with that in mind, we really should be like even the stuff we think is ridiculous and impossible and all posture and all chest puffing, we should really be looking at because you never know with this administration. This administration is like somebody with like a serious mental disorder, somebody with like serious schizophrenia or serious psychopathy, where when you're next to them, when you're interacting with them, they're that kind of person that gives you the vibe that they could just snap at any moment and they might just start swinging at you or something, even though you've done nothing but be nice to them. That is what this administration is. They're the psycho.